Hi there, Attorney Chuck Shire. You know my law firm, Shire & Ritchie, right here in East Peoria, 839-2024, or on the web at srtriallawyers.com. We have a brand new website, so if you want to check that out at srtriallawyers.com, that would be much appreciated. So we get a lot of questions about planning for the future, and there's always an answer that we give over and over again, and I realize there are three real important documents that everyone needs to have, and in fact you need to have them. If you don't have them, that's okay. That's okay. You can get it taken care of. You can call our firm. You can even do some of this stuff online, although I wouldn't necessarily recommend that. Or you can call another lawyer, but you need to have three important legal documents, and I bet you can all guess what number one is, and that is a will. Of course you need to have a will. If you do not have a will, the state is going to decide how your items, your property is distributed. Now, in the state of Illinois, if you're married, half of that's going to, by law, go to your spouse. But let's say you don't have a spouse and you don't have a will. The state would look for any children you might have. If you didn't have children, then it would look for parents, siblings, aunts, uncles, cousins, right on down the line. So, of course, you don't want that. And you don't want your family members fighting over whatever it is that you have. And so you want to put it down in a will. And this will is going to accomplish a couple of different things. One, it's going to avoid probate. So that means we're going to avoid that court process of trying to determine who takes title to your property. Right? So you're going to give all those different things to your kids or to your spouse, and you're going to lay it all out so that when you pass away, your loved ones don't even have to worry about it. They're going to have a lot of other things that they're dealing with, thinking about. They're going to have the emotional, issues of having lost you. So to take that part away, to make things easier for those that you leave behind, a will is critically important. Now, a couple of different things in the state of Illinois. A will has to be witnessed, so it's got to be written, and it's got to be witnessed by two people who are disinterested, meaning that if you want to leave everything to your two kids, let's say you've got a son and a daughter, you want to leave everything to them, they can't be your two witnesses because they are interested in it. So just keep in mind, and these little technicalities are exactly why you should go see a lawyer in preparing your will. Now, in your will, you can also do other fun little things like set up a trust, appoint a guardian. Of course, you're going to want to appoint an executor, and an executor is essentially someone to get this legal issue past the goal line. So once you pass away, within 90 days, someone's going to file a copy of your will in the county in which you reside, or the county in which you passed away, and that's going to start this process going. Now, one thing, remember, so document number one, you're going to get a will, but keep in mind what a will does not do. It is not going to pass title to stuff such as a bank account or your trading account, stuff like that. If you have a bank account, Commerce Bank, SEFCU, whatever, you need to go to that bank and you need to fill out a payable on death form. They probably gave that to you when you opened your account. But if you're like me, you've banked at the same place for 10, 15 years, and things in your life have changed. So you have to update those things. Let's say you got married. Let's say you got divorced and you got remarried. But you have the ex-spouse on your bank account. You pass away, the bank is going to pull that form and they're going to look right on down there, and it says give all the money to the ex. So keep in mind, those would be a disastrous outcome. This is all part of planning for the future, so you should take care of all of those types of things. So number one, is the will and all the different types of things that come along with a will. All right, number 2 is your healthcare power of attorney. As we get older, right, we're going to get some health problems. You can't avoid it. It's just a part of getting older. And sometimes those health problems mean that we could be in a surgery for, an hour or two, and we simply cannot answer any questions that a doctor may have. You could be in an automobile accident and you're unconscious when they get you to the hospital. So you want our document number 2, you absolutely need to have is your healthcare power of attorney. This is someone you know and trust and love. This is your spouse. This is your parent. It's a brother or sister, but somebody who really cares about you and someone you've had some conversations with, knows something about your current situation. And if medical professionals need to answer some questions and you are incapacitated, they can go talk to this person. This document is called a durable healthcare power of attorney. Now, why do we call it durable? It's not because it's made of steel. It just survives your incapacitation. So right now I'm up and talking, but if I were unconscious, I would have a document that my wife could then talk to the medical providers and make decisions for me. All right, document number 3, not to be confused with the healthcare power of attorney, but this is your living will. All right, a living will is essentially, I don't want machines to keep me alive. Now, typically, the way we write these things is that the attending physician, it has to be signed off by another physician, and essentially the language is going to be that you're in an irreversible coma or you're in what's called a persistent vegetative state. You're not coming back, okay? And if you have a machine that's actually breathing for you, then this is your declaration that it's okay to turn it off. Now, if that's something that is important to you, I strongly recommend that you do that. And this is an agonizing decision for your loved ones. They do not want to have to make that decision. If it's mom or it's dad, your kids do not want to tell the doctors to turn off the machine. All right? So that is something that if that's what you want, you need to do that while you're upright. Okay? So you take that pain and sorrow and anguish and stress away from your loved ones, your kids or your spouse. And if the medical providers turn off the machines based on something that you filled out and you wrote and you signed, that's going to make things a lot easier. It'll be easy for your loved ones to accept that decision in the moment. If you leave it to your kids, let's say, to make that decision, they're always going to question it, no matter what. Even if it was the right decision, and probably would have been, but they're still going to question it. It'll make it a lot easier for them if they never had to make that decision. You made that decision. So here's your 3 documents. You need to have a will, a healthcare power of attorney, and a living will. If you don't have those, get those. They're not that expensive, and it's very important. We do them here at Shire and Ritchie because primarily we do a lot of personal injury, and somebody will come in and they'll get a settlement, and all of a sudden they have some money that they didn't have previously. And anytime you have these life changes, not just whether or not you were paid some money, but let's say you got married, you got divorced, someone died, you got a new job, you've moved. Anytime there's these new life major events, you really need to start thinking about what you have, and you got to start thinking about the future. If you've got parents that are getting older, you got to sit down and have a difficult conversation. What's going to happen to their stuff? What do they want to do with their estate? What if they have a house? Do they want it sold? If there are 2 kids, 3 kids, 4 kids, do you want them all involved as the executor? Do we want the oldest one involved? A lot of times the parents will choose the oldest child. That's not always the best choice. Sometimes it's the middle child or the youngest child, but so these are things that you need to make a decision, and you got to make a thoughtful decision. So it takes a little bit of time to sit down and think about these things. But in any event, those are 3 legal documents. If you don't have them, get them. If you've got any questions, we're happy to answer them. Shire and Ritchie in East Peoria, 839-2024, or on the web at srtriallawyers.com. Have a great day. Thanks for joining us.